Proceed.
Mr. Speaker, whereas the Constitution of Kenya 2010 Article 1811 provides for the removal of a county governor from office on the grounds of gross violation of the Constitution or any other law, abuse of office or gross misconduct, or if there are reasonable grounds to believe that the county governor has committed a crime under national or international law, and whereas Section 33 of the County Governments Act 2012 further elaborates the procedure and the grounds for the removal of a county governor, aware that the standing orders of the County Assembly of Nyamira and the standing orders of the Senate provide the procedural framework for such a motion, cognizant of the fact that all state officers are required to act within and in accordance with the Constitution and laws, exercise authority and perform public functions with respect and honor, be accountable to the public for their decisions and actions, and use public funds in accordance with the Constitution and the law. Noting with grave concern that His Excellency Amos Nyaribo, Governor of Nyamira County, has not just strayed, but has galloped outside the confines of the Constitution, brazenly circumvented the laws, grossly violated the Constitution, failed to guard public funds, and deliberately executed corrupt practices in management of county affairs, leading to massive loss of public funds, Mr. Speaker. Now, therefore, I, the undersigned member of the County Assembly of Nyamira, move the motion for the removal of His Excellency Amos Nyaribo from office of County Governor, Nyamira County, by way of impeachment. Honorable Speaker, I now proceed to state the grounds for impeachment and or specific particulars, a narrative of betrayal and the constitutional delinquents, Mr. Speaker. Grounds for impeachment. The grounds below paint a pattern of blatant constitutional disregard and fiscal impropriety by Honorable Amos Nyaribo, Governor of Nyamira County. Ground 1, gross violation of the Constitution and other laws. Particular 1.1, gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 through deliberate formal engagement, endorsement and support of an unlawful, illegal, unconstitutional bunge machinani. Whereas Article 1, 10 and 73 of the Constitution 2010 enshrine the principles of sovereignty of the people, the rule of law, and the responsibilities of state officers. Whereas Article 176.1 of the Constitution of Kenya 2010 unequivocally establishes the County Assembly for each county, and Section B2, 7B2 and 14.1a of the County Governments Act 2012 govern the lawful sittings and procedure of the County Assembly, whereas Section 6A1 and the third schedule of the County Governments Act 2012 specifies the location of the Nyamira County Government as the Nyamira urban area, whereas Section 7.2b 7B2 of the County Governments Act 2012 provides that, except for a sitting of a new county assembly under Section 1, a sitting of a county assembly may be held at any place within the county and may commence at any time as the county assembly may appoint. Whereas Section 32A of the County Governments Act 2012 requires the government to diligently execute the functions and exercise the authority provided for in the Constitution and the legislation, whereas Section 33C of the County Governments Act 2012 requires the governor to promote democracy and good governance, unity, cohesion within the county. His Excellency Amos Nyaribo deliberately engaged, endorsed and supported an unlawful, illegal and unconstitutional bunge machinani gazetted by Enoch Ogori Okero by the Kenya Gazette Notice number 14229 of 2024, dated the 29th of October 2024. And the appointment of an acting clerk by the Kenya Gazette Notice number 14230 of 2024. There is Annex 1.1/1, despite the knowledge that the facts, despite knowledge of the fact that the said Enoch Okero had been removed from office of Speaker by way of impeachment, as is published in the Kenya Gazette Notice of Notice number 14050 of 2024, dated 25th October 2024, as seen in Annex CAN 11/2, Mr. Speaker. The Senate of the Republic of Kenya on 15th May 2025, while considering a progress report of the Standing Committee on Devolution and Intergovernmental Relations on the operational and leadership crisis affecting the County Assembly of Nyamira, resolved that, and I quote, the decision and resolutions made by the impeached Speaker and members of the County Assembly that convened outside the gazetted precincts of the County Assembly are null and void, Mr. Speaker. The same was communicated to the clerk of the County Assembly of Nyamira and copied to the Governor of Nyamira County via letter reference number SEN/Resolves/17/2025, dated 22nd May 2025, Mr. Speaker, as per Annex 1.1/03. The impeachment of Enoch Okero was affirmed by the judgment of the High Court at Bomet in petition number E004 of 2025, Mr. Speaker, delivered on the 4th May of June 2025. In paragraph 74 of the said judgment, it was the court's finding that the seventh respondent, into brackets Enoch Okero, the impeached Speaker, ceased to hold office on 24th of October 2024. Further, in paragraph 85 of the same judgment, the court found that any actions or duties performed by the seventh respondent, Enoch Okero, the impeached Speaker, were illegal, null and void, as the seventh respondent neither had the power nor the locus to do so, as shown in Annex CAN/11/04. Whereas the governor and his accomplices maintained that there were court orders stopping the County Assembly from removing Enoch Okero from the office of Speaker, the High Court at Bomet, by judgment in petition number E004 of 2025, delivered on the 4th day of June 2025, settled this matter and held that there was no such order and that the county was not barred from impeaching Enoch Okero from the office of Speaker or exercising its constitutional mandate. The same is found in paragraph 72 of the said judgment, where the court held that this court's critical interpretation of Order Number 2, issued on the 11th of October 2024 by Okwani J, was that she issued conservative orders stating the suspension of the seventh respondent as Speaker. This effectively meant that the seventh respondent assumed his duties as Speaker of the County Assembly. In regards to Order Number 3, the judge issued conservatory orders that barred interference of the duties of the seventh respondent as Speaker. Order 3, as worded above, did not mention the County Assembly of Nyamira was barred from impeaching the seventh respondent or exercising its constitutional mandate. His Excellency Governor Amos Nyaribo consistently and deliberately supported the engaged with gatherings of an unlawful, illegal, and unconstitutional bunge machinani, which conducted its meetings from October 31st, 2024 up to June 2025, in locations away from the lawful and the official gazetted premises of the county assembly and without lawful in appointment.
Order, Honorable Matwere, assume your seat. Such terms, anybody who has entered the chambers without following the procedure? Order, close the door. Order. The respect for the chambers has to be followed up to the letter. Such terms, make sure before you usher in any visitor, you inform him or her of the procedures on how to enter the chambers. Proceed, Honorable Matwere. Proceed. This is a house of law, and the law has to be followed.
Thank you, Honorable Speaker. His Excellency Amos Nyaribo consistently and deliberately supported and engaged with gatherings of an unlawful, illegal, and unconstitutional bunge mashinani, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the law and the official gazetted premises of the county assembly and without law for appointments. Further, the governor made public pronouncements declaring Enoch Ogorio and Silvanus Ndemwanyamora as the legitimate speaker and clerk respectively, while aware that Enoch Ogorio was duly impeached as per Annex CAN/1 11 Volume 1. The government's actions to formally engage in those under law and support an unlawful, illegal, and unconstitutional bunge mashinani directly undermines the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and the County Governments Act 2012, thereby constituting a gross violation of rule of law and the principle of separation of powers. Particular 1.2, Mr. Speaker, gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on democratic principles and the separation of powers, whereas Article 1851 of the Constitution of Kenya 2010 states that the legislative authority of a county is vested in and exercised by its county assembly, whereas Article 224 of the Constitution of Kenya 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriations bill in the form and according to the procedure prescribed in an Act of Parliament. Whereas Section 21(1) of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor. Whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the county assembly for consideration and approval. Honorable Speaker, the Governor on 26 November 2024 assented to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira, in total defiance to the constitutional principle of separation of power. The Nyamira County Supplementary Appropriations Bill 2024 is not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 26 November 2024 as per Annex CAN 12/05A and B. The Nyamira County Supplementary Appropriation Act 2024, as assented by the Governor, significantly altered the priorities and the development programs in the original approved budget as per Annex CAN/1-2/06. Honorable Speaker, this conduct constitutes a gross violation of Article 175A, 1851, 224 of the Constitution of Kenya 2010, Section 130 of the Public Finance Management Act 2012, Section 21(1) of the County Governments Act 2012, and Order Number 137(1) of the County Assembly of Nyamira Standing Orders, and the due process of the law, which requires that the county budget be approved by the County Assembly. The same undermined the representation and oversight role of the County Assembly. The supplementary budget was assented to, devoid of a participation of the people and all their representatives. Particular 1.3, Mr. Speaker, is on gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing Dr. Paris Nyaribo Oroko, alias Paris Mungare, to the County Executive Committee, CEC, without approval of the County Assembly. Whereas Article 179(2)(b) of the Constitution of Kenya 2010 provides that the County Executive Committee shall consist of members appointed by the County Governor with the approval of the Assembly from among persons who are not members of the Assembly. Whereas Article 259 of the Constitution emphasizes the interpretation of the Constitution, which includes the respect for judicial pronouncements. Further, whereas Section 30D of the Constitution of the County Governments Act 2012 requires the governor to appoint, with the approval of the County Assembly, members of the County Executive Committee. Whereas Section 4 of the Public Appointment County Assembly's Approval Act 2017 requires that an appointment under the Constitution or another law for which the approval of a County Assembly is required shall not be made unless the appointment is approved by the relevant County Assembly in accordance with this Act. His Excellency Amos Nyaribo appointed Dr. Paris Nyaribo Oroko to the County Executive Committee without the approval of the County Assembly of Nyamira, in total disregard of the due process of the law. In response to an inquiry by the County Assembly, the County Executive Committee member for Public Service Management maintained that Dr. Paris Nyaribo Oroko is duly appointed as per Annex CAN/13/07A and B. Failure to submit the name of Dr. Paris Nyaribo Oroko for vetting and approval by the County Assembly of Nyamira constitutes gross violation of Article 179(2)(b) and 259 of the Constitution of Kenya 2010 and Section 30D of the County Governments Act 2012. Honorable Speaker, the Governor has to date proceeded to retain Dr. Paris Nyaribo Oroko and supervised her integration into the payroll system since June 21st, 2025, and authorized the payment of our salary and allowances despite clear judicial and senatorial pronouncements declaring all actions of Bunge Mashinan as illegal, null, and void. As per Annex CAN 13/08A and B, Annex CA 11/03, Annex CAN 11/4. The Governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. This action brazenly bypassed the County Assembly, constituting a gross violation of the Constitution and the statutory provisions governing appointments. Particular 1.4 on gross violation of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, and the Public Appointments County Assembly's Approval Act 2017 by appointing Nyamira and the Keroka municipalities board members without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Section 14.1 of the Urban Areas and Cities Act 2011, as amended 2019, requires that a board of a municipality shall consist of 9 members appointed by the county governor with the approval of the county assembly. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or another law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with these acts. His Excellency Amos Nyaribo, by the Gazette Notice number 1965 of 2025, dated 30th February 2025, appointed members of the boards of Keroka and Nyamira municipalities without the approval of the County Assembly of Nyamira, in direct defiance of the Constitution of Kenya 2010, the Urban Area Cities Act 2011, as amended in 2019, and the Public Appointments County Assemblies Approval Act 2017, as per Annex CAN 14/09. The approval of members of the 2 boards was not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 19th November 2024, as per Annex CAN 14/10A and B. The governor has to date retained the said board members in defiance of clear judicial and senatorial pronouncements as per Annex CAN 11/03, Annex CAN 11/04. This constitutes a blatant disregard for the rule of law and a contempt for legitimate authority. Honorable Speaker, Particular 1(5) on gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing the selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSP, without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73 and 74 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparent and fair competition and merit. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. The governor appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board without the approval of the county assembly of Nyamira. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. The selection panel proceeded to invite, shortlist, and conduct interviews for applicants for the positions of chairperson, secretary, and members of the Nyamira County Public Service Board in total defiance of clear judicial and senatorial pronouncements as per Annex 11/03, Annex CAN 11/04, Annex 1(5), Annex CAN 1(5)/11A and B. These actions are contrary to constitutional principles and undermine public service integrity. Particular 1.6 on gross violation of the Constitution of Kenya 2010, County Governments Act 2012 by failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Whereas Article 235 of the Constitution of Kenya 2010 provides that a county government is responsible for A, establishing and abolishing offices in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over removing persons holding or acting in those offices. Whereas Section 58A(1) of the County Governments Act 2012 provides that whenever vacancy arises in a county public service board, the governor shall nominate, and with the approval of the county assembly, appoint members to a selection panel for the purpose of selecting suitable candidates for appointment as members of the county public service board. And whereas Section 58A Subarticle 7 provides that the governor shall, within 7 days of receipt of the names forwarded under subsection 6, nominate one person, and at least 3, but not more than 5 others for appointment as chairperson and members of the County Public Service Board, respectively, and forward the names to the County Assembly for approval. The Governor, His Excellency Amos Nyaribo, has to date failed to nominate for vetting, approval, and appointment of the chairperson, secretary, and members of the County Public Service Board, despite vacancies arising in the Nyamira County Public Service Board as from 5th of July 2025. The absence of a county public service board has created a lacuna in the management of the human resource function of the county government of Nyamira. In the obtaining circumstances, the provisions of Article 235 of the Constitution of Kenya 2010 cannot be realized in the county Nyamira County Public Service. Additionally, this has eroded confidence and the public trust in the leadership of Governor Amos Nyaribo. Particular 1.7, Mr. Speaker, is on gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by failing to submit annual reports and deliver annual state of county address to the County Assembly for 2 consecutive years. Mr. Speaker, whereas Article 183(3) of the Constitution of Kenya 2010 provides that the County Executive Committee shall provide the County Assembly with full and regular reports on matters relating to the county, and Section 30, Subarticle 2J and K of the County Governments Act 2012 mandates the Governor to 1. J. Submit to the County Assembly an annual report on the implementation status of the county policies and plans. K. Deliver annual state of the county address containing such matters as may be specified in county legislation. The Governor has failed to submit annual reports and deliver annual state of the county address to the County Assembly of Nyamira for the past 2 consecutive years, that is 2023, 2024, 2024, 2025, as required by laws. This failure constitutes a gross violation of constitutional and statutory provisions, demonstrating a blatant disregard for transparency, accountability, and the oversight role of the County Assembly. It further denies residents of Nyamira County an opportunity to hold their governor accountable. The governor's consistent and prolonged failure to deliver the constitutionally required state of the county address demonstrates a deliberate act to evade accountability to the County Assembly and the people, thereby constituting a gross violation of constitutional and statutory mandates. This is as per Annexure CAN 17/12, which is a sworn affidavit by a leader of majority party in Nyamira County Assembly. Particular 1.8, Honorable Speaker, is on gross violation of the Constitution of Kenya 2010 by failing to appoint and obey court orders regarding the appointment of Clive Ogwora to the County Executive Committee. Whereas Article 159(1) of the Constitution of Kenya 2010 provides for the exercise of judicial authority, whereas Section 4(1)(a) of the Contempt of Court Act 2016 provides that the contempt of court includes a contempt which means willful disobedience of any judgment, decree, direction, order, or another process of a court, or willful breach of an undertaking given to a court. Whereas the Employment and Labor Relations Court at Kisumu in ELRC JR number 10 of 2021 ordered the governor to appoint and pay salaries to Mr. Clive Ogwora. His Excellency Amos Nyaribo failed to appoint Mr. Clive Ogwora nominee for member of the County Executive Committee, despite the fact that nomination was cleared by law for appointment. The governor's disobedience of the High Court's order directing him to appoint Mr. Clive Ogwora resulted in the loss of a decretal sum of 4,417,875. The actions of the governor, including delayed settlement, resulted into loss of public funds amounting to 6,922,203.75 million, being the decretal sum plus costs, interests, and other incidentals. This is as per Annexure CAN 1.8/13A on that case of ELRC JR number 10 of 2021 at the Kisumu Employment and Labor Relations Court's judgment. Then there is another annexure CAN 1.8/13B, which is a consent dated 6th July 2023 and recorded in court on the 1st July 2023. Ground 2, Honorable Speaker, on abuse of office. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability, among others. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer benefit on himself or anyone else is guilty of an offense. His Excellency Amos Nyaribo abused his office in the management and administration of county affairs through the following acts as particularized below. Particular 2.1, Mr. Speaker. On abuse of office by improper use of his authority in procurement, in recruitment of staff without approved budget, which we call the recruitment frenzy, Mr. Speaker. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, 75 of the Constitution 2010 outlines the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 201A, D, and the E of the Constitution of Kenya 2010 state as follows. A, there shall be openness and accountability, including public participation in financial matters. B, public money shall be used in a prudent and responsible way. E, financial management shall be responsible and the fiscal reporting shall be clear. Whereas Article 232(1) of the Constitution 2010 states the values and principles of public service requiring efficient use of resources, transparency, and fair competition and merit. And whereas Section 1072(c) of the Public Finance Management Act 2012 requires that the county government's expenditure on wages and benefits for its public officers shall not exceed a percentage of the county government's total revenue as prescribed by the county executive member for finance in regulations and approved by the county assembly. Whereas Section 8(1)(c) of the County Governments Act 2012, which provides for the role of the county assembly, including approve the budget and expenditure of the county government in accordance with Article 207 of the Constitution, and the legislation contemplated in Article 222 of the Constitution, guided by Articles 201 and 203 of the Constitution. His Excellency the Governor presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Committee minutes. That is minute number 04/02/2020 of 2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with the full knowledge that there was no budgetary provision. In the said response to issue number 4 in question, the Governor alleged that in lieu of a budget, the recruitment was based on the savings made from various separations, which included but not limited to retirement and resignations. Despite a resolution of the County Assembly to freeze new employments on account of lack of budgetary provision for any new recruitment dated 1st July 2021, which freezing was never vacated by a resolution of the County Assembly. Further, in spite of an advisory from the Secretary of the County Public Service Board dated 29 July 2021 to the County Executive to put the imbuing the recruitment in abeyance, considering that there is no budgetary provision for any new recruitment. His Excellency Nyaribo has to date proceeded with a recruitment frenzy that has ballooned the county wage bill, making it unsustainable, irresponsible, and imprudent, contrary to the provisions of the Public Finance Management Act 2012. The Governor has influence on the recruitment of hundreds of staff without a budget, in areas of EACC, advisory and county assembly resolutions for political expedience and personal gain, constitutes a clear abuse of office aimed at fiscal plunder and a violation of constitutional values and principles of governance. Since the year 2021, when His Excellency Nyaribo assumed the office as a governor, he has influenced the recruitment of staff without budgetary provision and approval of the County Assembly of Nyamira, and particularly in February to April 2021, there was a recruitment of 49 officers. B, the recruitment of the Deputy County Secretary, County Attorney, support staff, ward and sub-county administrators. On March 9, 2023, the County Public Service Board advertised for 358 vacancies despite lack of approved budget for recruitment, a recruitment freeze by the County Assembly, and disregard for EACC advisories. This recruitment projected to add Kenya shillings 312 million annually, proceeded without any budgetary allocation or approval. Outstanding arrears to the tune of 60 million arising from unpaid salaries to healthcare workers for a period of 7 months. This is as per Annex EAN21, stroke 14A and B, on Governor's response to control of budget dated 18th November 2021 and 3rd January 2024. At the same time, on Annex CAN 2.1, stroke 15A, which is an advisory letter from the Secretary, County Public Service Board on freezing recruitment due to lack of budget. Annex CAN 2.1, stroke 15B, is a letter from the County Assembly communicating freeze of employment. There is also Annex CAN 21/16 on advertisement for 358 vacancies. There is also an Annex CAN 21/17 ABC on approved budget estimates 2021, 2022, 2022, 2023, and 2023, 2024 showing no allocation. Particular 2.2 is on abuse of office by influencing the appointment of Godfrey Kiriago and Imelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management stroke payroll manager, respectively. Whereas Article 179 of the Constitution designates the county governor as the chief executive of the county, whereas Article 232(1)G of the Constitution of Kenya 2010 mandates fair competition and merit as the basis for appointments and the right to equality and freedom from discrimination, whereas Article 75, 76, 77 of the Constitution govern the conduct and financial property of state officers, whereas Section 30 of the County Governments Act 2012 provides for the functions of the governor, whereas Section 45 of the Anti-Corruption and Economic Crimes Act 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. In a letter dated 18 January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Amos Nyaribo, to the County Public Service Board seeking the secondment of two cherry-picked officers, Godfrey Kiriago and Imelda Nyaberi, to the positions of Director Human Resource and the Payroll Manager, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said officers ought to be vacant and that the process must follow the laid down procedures and the legal provisions. The governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and caused the irregular integration into the county payroll. By initiating the non-competitive appointment and the retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of office, leading to a direct and a quantifiable loss of public funds, since the two offices were hitherto substantively occupied. The governor further influenced the appointment of Mr. Kiriago Godfrey to the position of Deputy County Secretary and influenced the renewal of Ms. Imelda Nyaberi's contract post her retirement age. This is as per Annex CA12/18, a letter from the County Secretary to the Chairman, County Public Service Board, dated 18 January 2021, requesting for secondment of the two officers. Annex CAN 2.2/19, which is a response of the Chairman, County Public Service Board, dated 19 January 2021, advising that the secondment has to follow due process. Annex CAN 2.2/20 on appointment is an appointment letter for Kiriago. Annex 2.2/21A is an appointment letter for Imelda Nyaberi. Annex CAN 22/21A is on Kiriago. Annex 22/22 is an annex on appointment letter for Godfrey Kiriago as Deputy County Secretary. Annex CAN 2.2/23 is on a contract renewal letter for Mr. Imelda Nyaberi. Annex CAN 2.2/23B is a witness statement by one DMO. Particular 2.3 Honorable Speaker, is on abuse of office through personal enrichment from receipts of irregular salary arrears of Kenya shillings 5,649,706. Whereas Article 201A, D and E of the Constitution of Kenya state as follows: there shall be openness and accountability, including public participation in financial matters. F, public money shall be used in a prudent and responsible way. G, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission to set and regularly review the remuneration and the benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, that is the PMF Act, requires public funds to be used in accordance with the law and for the purpose for which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. Mr. Speaker, in September 2021, through the facilitation of the two cherry-picked officers, Mr. Godfrey Kriago, Director Human Resource, and Imelda Nyaberi, Payroll Manager, the Governor conferred upon himself an irregular salary payment christened as arrears amounting to 5,649,706. It's apparent that there was no outstanding arrears due to the governor since his assumption to office, and neither was he owed any arrears as deputy governor. The governor has self-authorized the receipt of 5,649,706 in salary arrears outside of Salaries and Remuneration Commission guidelines is a clear act of personal enrichment, abuse of office, and a direct violation of the PFM Act. The governor has publicly confessed that he received the above irregular payment. The people of Nyamira lost services and development programs to the tune of 5.6 million on account of this office and all his actions. The governor has formed the habit of conferring upon himself irregular benefits going by other instances, for instance, in the year 2019, the governor caused to be paid a retrospective compensation of 13 million in allowances for housing, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF or outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment through corrupt XCAN 2.3/24 SRC, which is an code which led to massive loss of public funds through huge, irregular, and 852. Ms. Gladys Moran Nyambana, an ACD teacher, received one. It's also an XCAN 24/28 of a January 2023 dual appointments outside the lawful establishment. A county government is responsible within a framework of uniform norms and standards prescribed. B, appointing persons to hold or act in those offices and confirming appointments Act 20. By the Auditor General at his or her own initiative or upon request by the governor has not requested the Auditor General to carry out any audit. The Auditor General to carry out any audit. the of services of technical aid 229, Section 37 of the Public 9, Section 37 of the Public Audit Act 2015, establish fraud, corruption, or financial placed to Parliament or the County Assembly for debate, and the consideration where appropriate resolutions are, and the actions where appropriate resolutions are, and the actions
more ushering in of any visitors.